India Confederation of the Blind. Training workshop on the rights of persons with disabilities with particular emphasis on the visually impaired for AICB affiliates in South India. Sponsored by Danish Association of the Blind. So now we will begin the session. We have, because we were all expecting the session very eagerly. So we have our President and Advocacy Chair, Dr. Anil Aneja, sir, who will deal more about reservation, roster, etc. Over to you, sir.
Okay, so good morning, everyone. The reason why we have made this slight change in the program is, you may recall that my talk remained inconclusive on employment and social security last week. And this being an important topic, it was felt that maybe some more time should be given so that our participants can understand some of the important nuances and final points of reservation and employment related issues. So I will be brief because many things have to be covered in this session. We have to cover, Muthu also has to take the RTI and RTE Act, or maybe I do that, let's see how it goes. Also some AICB achievements. And we have an outside speaker at 10:45. So we should conclude the session in time so that the outside speaker doesn't need to wait. So you should remember, I had told you last week that though we associate reservation with the 1995 Act, but in effect, the reservation for persons with disabilities in some form or the other started much earlier than that. It was in 1977 that 3% seats were reserved for persons with disabilities. Disabilities as these were defined at that time, on 1% for visually impaired, 1% for locomotor, and 1% for hearing impaired. At that time, the term was used of orthopedic and group C and D services. 86 was the first list of identified posts, even for group A and B. 1989, we had the reservation in promotion. There's not a debate about reservation in promotion these days, whether it should be there or not. We'll address that question. But many organizations, government bodies are saying, because the 1995 Act is now null and void. The circular issued under that are also null and void, and therefore reservation and promotion is not applicable. The matter has been in the Supreme Court, and there have been many judgments on that. But people often forget that the reservation in promotion, as far as Group C and D services are concerned, has nothing to do with 1995 Act. It was correlation people are trying to establish between the reservation in promotion and 1990 is totally misplaced, because the provision was given earlier in 1989 and it was only protected in 1995. Yes, as far as reservation in Group A and B services is concerned, we should say that the issue became relevant only after the 1995 Act. So there is a long history and there's a greater development. In 2013, there was a judgment of the Supreme Court of India, a very important judgment on reservation. Because there were two disputes. One was whether reservation in Group A and B services is applicable. That was one point of dispute. The second was, it was applicable, but the issue was whether the reservation should be post-based or vacancy-based. And the third was whether the reservation should be on identified posts or on total posts. These three issues had been adjudicated by the courts time and again. But in a comprehensive judgment of the Supreme Court of India, it was clearly held that one, reservation is applicable irrespective of the mode of recruitment. That is, in all services, Group A, B, C, and D. And this is where from we also derive the issue of reservation in promotion, because if it is applicable on all modes of recruitment, then promotion is also a form of recruitment on a post. So it should be applicable on promotion also. And therefore, there have been judgment in 2015, 2016, 2017, 2020, and many more. validating the claim that there should be reservation in promotion. Just give me a minute. Yeah. The second point that Supreme Court judgment had in 2013 was that it should be both on identified and unidentified posts. On the total number of not posts, it should be vacancy based, it should not be post based. And there's a difference between vacancy based and post based, which I had tried to demonstrate last time. That there can be 10 posts per 100 vacancies may arise out of them in the times to come. But whereas if you make it post-based, then the calculation would always remain on 10 posts. And therefore, once one post vacancy is filled for PWD, no other post would ever be assigned in that organization unless the number of posts increases. In a vacancy base, 10 posts equals one vacancy, 10 posts means 10 vacancies. And then if anyone resigns or passes away or is terminated or a new post comes or any other reason, if a vacancy, a substantive vacancy occurs, that will be counted as 11th, 12th, 13th, 14th, and so on and so forth. So the number of vacancies will keep increasing, whereas the number of posts will remain static. That is the difference between post-based and vacancy-based rosters. So vacancy-based is good for us. It's much better than post-based for us as far as the quantum of reservation is concerned, though at one time it was fed by the sector that the reservation should be post-based and not vacancy-based. Just a minute. And as I said, there have been a number of judgments on this issue in the early part of the 21st century, particularly between 2006 and 2014. In 2013, there were a number of judgments and issues were adjudicated even in the Delhi High Court and then in the Supreme Court. And the Supreme Court judgment is now final on this point. So the question arises as to, okay, all this is fine, but what is reservation? What do we mean by reservation? It all sounds very nice. Does it mean that every person with disability will get a job? No, it does not mean that. It only means that in any establishment, and the definition of established is there, any organization. I'm talking about in the context of 2016 Act, and I'm talking of the definition of establishment in terms of government establishment. So any organization which is substantially managed, funded, owned, etc., by the government, that typically means more than 50% stake or financial support to the organization is called the government establishment. Just a minute, give me a minute. It's very hot in Delhi today. Yeah, it's called a government establishment. Now, in every government establishment, then there would be 4% vacancies reserved for persons with disabilities, and it's not just 4%, it's 1% of each of the disabilities. 1% for blind and low vision, 1% for the hearing impaired, 1% for locomotor disabilities, and 1% for other disabilities, intellectual disability, specific learning disabilities, and so on and so forth. So to effect, there's also a clause in section 34 that reservation is there, very good. But the government, in consultation with the chief commissioner, may exempt any organization partly or fully from the provisions of this reservation. Now, this is a modification from the 1995 Act, modification not to our advantage in a way. Earlier, provision was that there will be a committee in the Ministry of Social Justice and Empowerment, and that would examine whether exemption would be granted or not. A very important case that had come up before this committee was for the Ministry of Railways. When we filed a case, AICB filed a case in 2005 against the Ministry of Railways because the ministry had advertised for 8,000 vacancies and no reservation was given for visually impaired persons. So we filed a case which ran for 7 years in the Delhi High Court, and many, of course, you can imagine how a number of hearings which must have been had. We have Rajan Mani in the afternoon, and hopefully he will be talking about this case because he was our lead advocate in that case. So I will not talk much, but one of the issues came in that case was the railway wanted a exemption from reservation on technical posts, even for the orthopedic knee handicap. Of course, for visually impaired, the technical posts were not identified. And the reservation, as I told you last time, when I dealt with the identification clause, are only on the identified posts. But the technical posts are identified for the orthopedic knee handicap, but the Ministry of Railway wanted exemption even from those provisions for the exemption for the orthopedic knee handicap. Then no reservation would be given. So they tried for 5 years. With the Ministry of Social Justice and Empowerment, the committee did not grant that exemption to them. Ultimately, railways had to concede because there were people in that committee who were from the disability sector as a part of the constitution of the committee, and they would not allow such an exemption to go through. But now in the new provision, there's a problem. Because Chief Commissioner is also, in a manner of speaking, though it's supposed to be an independent body, is a part of the ministry. As we know, in today's context, the Secretary, Ministry of Social Justice and Empowerment, in charge of disability affairs, is also holding the charge of Chief Commissioner. So if the Secretary so desires to, I won't say favor, but to provide, to grant exemption to any organization from reservation of PWD, and there are many such demands. Don't think people are very open to giving reservation because law is there. No. There are not a resistance to reservation. Even today, the maximum number of cases in the courts are on employment and reservation. Even today, after 2 acts being in place, even today, the maximum number of cases are on employment and reservation, including AICB cases. Most of our cases have been on employment and reservation. So, this is a negative clause, I believe, because if the same person acts as Secretary and Chief Commissioner, and if the act says the government in consultation with the Chief Commissioner, whom are we consulting? The Secretary herself is the Chief Commissioner, consulting herself and giving a power to one person to give exemption. And that's not good. And you know, recently, in some last year, I think it was, or 2019 or 2020 or 21, some departments, some ministries, some certain kind of posts have been exempted from reservation. And there's a more and more tendencies towards such things. People are showing difficulty in functioning and seeking exemption. And which is a clause we need to be very careful with and we need to be monitoring. So how does reservation get affected? There's a term called rosters. This section 34 also has to be read with an office memorandum issued by the Department of Personnel and Training on 15 January 2018. And also the list of identified posts issued by the Ministry of Social Justice and Empowerment on 4th January 2021. These 2 documents are extremely important because any reservation is based on that. Anybody, any government body providing resolution to persons with disabilities would and should look at these 2 documents. And therefore, it's very important if you want to ensure a proper quantum of reservation for ourselves that these two documents are studied by us also. Because unless we know this document, how are we going to ensure that these are implemented? This is the problem. We often ask for implementation of reservation. We often want this, that, but the problem is we have not done the documents ourselves. We don't know what the provisions are. We go by what we think ought to be. Law is not a channel of demand. Please remember that. Law is not a channel of demand. That you want something, it should be this way, so it should be. No. When you do an agitation, any organization, agitation, any representation, any case, you have to, number one, contextualize it in the context of an existing law. That what provision of law is being violated. That's very important to point out. Where? And if there's no existing law, then the second point is what fundamental principle or right of the given in the Constitution is being violated. And even that is not possible, you have to demonstrate what point of international convention or international treaty or international declaration or any other document of international bodies is violated. These are the 3 important instruments that we need to keep in mind when we talk about reservation or anything which is there with a view to ensure empowerment for persons with disabilities. First, what law is being violated. We need to demonstrate. We just cannot do this for us. No, that is demand. That's agitation. That is representation. You can write, you can demand. But when you argue legally on the basis of acts and policies, these are the three documents you need to keep in mind. One, law. Second, constitution. Third, international documents. And any petition in High Court, Chief Commissioner, State Commissioner, wherever, which is backed up by these three documents is a strong petition. Remember that. So please have knowledge. That's what we would expect as serious participants in this workshop from you, is to please read the applicable documents which are being discussed in this workshop. Read and understand. Please read the RPD Act. Please read the UNCRPD. Read not like a story bedtime. Nothing to do in the night, so might as well read. No. Give it a serious time. These are not very long documents, and try to understand. Ask people when you don't understand. There are enough resource persons in South India. MuthuSelvi is doing very good work, as we all know, in advocacy. And there are others. I'm sure every organization is doing good work. Habib is there. Swami Nayak ji is bringing up issues. Many people are there. So please, CSJB is doing good work. Every organization is doing good work. So please consult each other, have discussions, and try to understand and use these documents. So now I want to briefly tell you what is a roster, because this is one area I've been involved with for 7.5 years. In fact, I was the first nodal officer for PWD of Delhi University after the 2013 judgment, in which there is this provision for a nodal officer. Now, who is a nodal officer for reservation for PWD? The distinction is there between a nodal officer and a liaison officer. For SC, ST, OBC, we have what the term called, the DOPT calls liaison officer. And these officers are to only link between the organization and the sectors concerned, specific sectors which they represent, and try to ensure that all rules are followed. But they do not enforce. As per clause 54.54 of the Supreme Court judgment of 2013, it says nodal officer responsible for the implementation of reservation will be personally held responsible and departmentally proceeded against in any default. So this is the point, that it is a person who is responsible for implementation of reservation, and it should be implemented. He or she has the responsibility for implementing reservation, which is different from being a liaison officer. That if it is not done, that means the nodal officer should technically report to the ministry in case the organization does not confide. And there is another provision in every organization called Grievance Redressal Officer for employment. If there every organization is to appoint a Grievance Redressal Officer in case there is any default in reservation, then the Grievance Redressal Officer should be the first channel of approach. And he or she is supposed to give a verdict, a decision on the petition within 2 weeks. And if you're not satisfied, or if the organization is not satisfied, you can go to a court of law then, or a district court. That is, but so when you have a grievance in your employment, the first channel is not the chief commissioner actually. It is the Grievance Redressal Officer as provided in section 23 of the RPD Act. And if the Grievance Redressal Officer is not there in your organization, that is a point for advocacy. Please ensure that Grievance Redressal Officers are appointed and in the organization, and if these are not, report to us as to which department, which ministry. It may not be in every office, but at least in every department or every ministry. Typically, the Grievance Redressal Officer should be in the controlling ministry of your office. And if he or she is not appointed in the controlling ministry of your office, then I suppose you need to do advocacy and write to government and ask for the appointment of a Grievance Redressal Officer. So that's important. So what is a roster? Roster is basically a record, and it's maintained by the nodal officer. He or she is responsible for signing and implementing the reservation, as I said, as mentioned in the Supreme Court judgment, that he is supposed to implement the reservation, and there should be no default in implementing the reservation. That means 4% reservation must be granted to persons with disability. That has to be ensured by a nodal officer. It is his or her responsibility, which is, as I said, different from a liaison officer for SC/ST. So in a way, the nodal officer PWD is much more empowered if he or she chooses to use the power. If people don't choose to use the power, we can't do anything about it. Then, of course, we can't do anything about it. So, how does the roster work? How does the nodal officer know which category to give reservation to? How does the nodal officer know on which post or which vacancy to give reservation to? How does the nodal officer know when to give reservation? So for this purpose, what the government says that there needs to be maintained a 100-point vacancy-based roster, which is again different from what we call the 200-point roster, which is maintained for SC, ST, OBC, and EWS. It's a different roster. Now, this is where default is occurring in most of the organizations. Most organizations are calculating the reservation on two ways. One, either they do it on the 200-point roster, they just see how many posts are there and give reservation, or they just see, okay, we are advertising 100,000 vacancies, so we can give these many. No, that is not the way. Those 1,000 vacancies or 100 vacancies which are being advertised must be first plotted in the roster. I can technically prove to you, being the other side and being a devil's advocate, that I advertise 100 vacancies and yet not give a reservation and then justify to all of you. Now, how does it work if there's a roster? Suppose you advertise vacancies in the roster. Suppose first vacancy is filled, second vacancy is filled. I advertised vacancies which are available for advertisement, vacancies 3 to 23, 22, 20 vacancies. No reservation comes because the reservation roster points are 1, 26, 51, and 76. So none of the reservation point is coming in is 20, so I'm not obliged to give you a reservation. Then I see the next few vacancies are filled or are already, we have PWD. And then I advertise from 27 to 46. Again, these are 20 vacancies. So no reservation point is coming because the reservation points are 1, 26, 51, 76, so no reservation. 40, so on and so forth. So I can create 100 vacancies and not give reservation and yet justify. In the court of law, the reservation is not applicable. That is the disadvantage and the advantage of a roster. Advantage because while this can be done, being technically speaking, as I said, being the good devil's advocate, because I worked from the other side also, so I know what the loopholes are also. But at the same time, the point is, if I'm bypassing the first vacancy or 26 vacancy, which is reserved for PWD, I have to ensure that that vacancy is filled by PWD first. And if it's not filled, then the subsequent vacancy needs to be in the first available. So actually speaking, again, if now I come back to the NGO side, from the government side, and say you cannot advertise the 27th vacancy for general in case the 26th vacancy is not filled by PWD. So no, even if it's 27, it's not covered by the reservation point. The fact is the reservation point was utilized by a general candidate or SC, ST, OBC, EWS, and therefore now you have to make up and give reservation on the first available vacant vacancy. So you cannot go ahead without giving reservation. So you see there are both sides to the coin. It's important to know both sides because government is wise now. The lawyers have studied the law. They, they know. I'm just checking. I'm just checking the time. Aishwarya, what's the time? Muthu?
Sir, it's 10:25.
25.
Okay. So, Muthu, you want to speak or you want me to go on?
No, you can go on, sir. This is very important.
But
I can cover it in my important circulars and memorandum also. No problem.
No, that is a knowledge. Okay, so let's see how we do it. So maybe another 5 minutes, Muthu, then you can take 10 minutes on the RTI Act or RT, and then we can do the 5 minutes question session.
Sure, sir. Okay.
Yeah. So it's important to know, as I was saying, both sides of law because the government bodies are now very wise. When the PWD Act came, nobody had read it. Even the NGO people hadn't read it. In every workshop, I think I mentioned to you last time also, that I used to ask people, have you read the Act? And nobody would be able to answer 2, 3, 4. Now I think things are a bit better. Everybody has read it. Surely, I don't know whether the sector has read the Act. Surely the government lawyers have read the Act very carefully. And they know where the loopholes are. And since they know where the loopholes are, they know how to get by. So we should also know where their loopholes are, and we should be able to counter those. It's very important to study the law. So this is the roster. Now, as I said, most establishment default in maintaining rosters. It's important to find RTIs. That's where I remember Muthu, she has to do RTI Act. It's important to find RTI and try to get copies of the rosters. Try to see whether the concerned departments and ministries in your concerned states are actually maintaining the 100-point PWD rosters. Typically, they will not be maintaining. I tell you, most universities, we at Delhi University do maintain a very strict 100-point vacancy-based roster, very strict. For all colleges, all group, teaching, non-teaching, in all humility, we challenge anyone in the country to tell us that our rosters are not as per DOPT or order. Our rosters are perfect, 100% perfect. I mean, I know, it's only a matter of fact, not matter of pride or whatever. It's a matter of fact that I'm just saying. But this is not the case most places. And this is an important area for advocacy then for you. Try to get copies of the rosters, write to the universities, government, state universities, ask them for copies of rosters. If they don't have, now typically what happens, because it's a Muthu's point she covered, but I want to tell you also. In RTI, we find our RTI and we are satisfied with whatever good or bad response we get with it. That is not right. If you're not satisfied, use the other channels of RTI, the channel of appeal. Give first appeal and go to the state commission, information commission or sector commission, where the case may be, and try to get after the organization till you get the information. Not just file just rupee ka RTI, 10 rupee RTI, and then be happy whatever has come. Most people, 99.9% people stop there. They file the RTI and stop there. No, you have to go. If information is not given properly, which is often the case because we have also done it in the government how to answer RTIs. We know the skills. So yeah. So if the information is not correct, not proper, not complete, then send to the first appeal, and then go to the state information commissioner or the center information commissioner. You need a lawyer there. You can argue yourself also, but get the information. Only when you put pressure in organization, the rosters will be maintained. So it's a big science. I can't tell you, but basically roster means every time a new post, first you plot all the posts which are there in the organization, 1, 2, as per whatever way, alphabetical or the date of occurrence, the date when those posts were created. Then every vacancy arising is entered separately, arising by virtue of death, passing away, resignation, termination, or any other reason, or a new post being created. And that you keep plotting under the original post, 1, 2, 3, 4, 5, it keeps going. So that is basically date of arising a vacancy is the point, that you keep plotting vacancies as they keep arising. Today, X has resigned, so 1 vacancy. Tomorrow, Y resigns, 2nd vacancy. Day after, Z resigns, 3rd vacancy, and so on and so forth. So vacancies, people keep leaving and coming, vacancies keep occurring. That's why vacancy-based roster is more beneficial for persons with disability. So, yeah. These are rosters. What happens? But all these nice provisions are there, but what happens? There's also a clause I want to touch. We all know Section 33, Section 34, which deal with employment and identification and employment. And often it is said that there's no reservation in the private bodies. Even I believe that in yesterday night, when I was reading the Act again for this talk, the section, and I found Section 35. Very interesting Section 35 of the Act. Nobody has taken it seriously, but I think high time we should take it seriously. The approved government would provide incentives to private bodies to, now look at next word, incentives why? To ensure that 5% of the workforce consists of persons with disability. To ensure. Who has to ensure? The government. And how to ensure? By providing incentives. And if the incentives are not meeting the yield, then more incentives need to be given. But the word ensure is very important. It is not to encourage or to, facilitate. It is to ensure. That means the duty to ensure that 5% workforce. I'm going to file the advocacy case very soon. on this point now. And because the government has to ensure, has that been ensured? Because the word is ensure, and incentives are there, but giving incentive is not enough. You have to ensure that 5%. So incentives don't work, then whatever other measures are there have to be put in place. Therefore, the direction and the code directions have to come in. So this nobody is ever filed, to my knowledge. I may be wrong. A case under Section 35. I mean to do this, and I suggest all of you also think of that. Give us the information in which private organization, how many persons with disability are working. We just filed RTIs to major private organizations, big, Reliance Industries, Tata's, Adani's, anyone, power companies, gas and petroleum companies, big companies. Find out, of course, some of the gas and petroleum companies are public sector, but private banks, yeah, that can be a good source, and see how the reservation is implemented, and then try to get a data. The word is ensure. I don't know whether we'll win or lose the case. We'll have to work out. But I think it's worth trying, because the word ensure is there to ensure that who is to ensure? The government. Incentives are a means. Incentives are not the end. Government is giving the incentives, whatever written incentive they're giving, but they're stopping there. But no, they have to go further to see whether those incentives are working. If they are not working, then further incentives need to be given, which is not being done. So that's very important. Then all this is very good, and the world should be a nice place to live in after all this, but no, it's not the case. As I said, most grievances, most defaults are with respect to employment, and by none other by the government, which is supposed to implement the act. We not find that most cases, 99.9% cases are not filed against the private bodies, but with the government. And they are supposed to implement. They're supposed to know that more than us, in fact. It's their job, not my job. But they don't know their job, unfortunately. So we need to go to a court of law. So how do we go to court of law? So there are various kinds of grievance mechanisms. One, we have the Office of the Chief Commissioner under Act 70, Section 75, 76, 77 of the RPD Act. Now, this is a very weak office. Unfortunately, it sounds very nice. There have been some very strong commissioners, chief commissioners, and deputy chief commissioners who have given very good orders. They knew their powers. It's all, you see, there is a statement somewhere I read that a sword is useless in the hands of a coward, but in the hands of a lion, it is a mighty weapon. So it's not the office per se, it is not the chair per se that decides whether you have the power or not. It is up to you to use whatever power is there in the chair. It is said that the American Disabilities Act of 1919 was a very strong act. It had everything possible. But the courts there had made it weaker and weaker by their judgments, because there are other rights, because society is much more self-driven there than in India. So people who are non-disabled also went to courts, and the act became weaker and weaker after that. In contrast, it is said that 1995 was particularly a generalized, very generic, weak kind of act. But the courts have made that act stronger by their judgments, by strong judgments. So it all depends how you use something. It does, and this is where in India, I believe the disability sector has a very important role to play. Of course, I must say, confess, and USA also, the organizations of the blind and other disabled are playing a very important role in ensuring rights. They to take up, even today there are violations. Don't think US is all hunky-dory, no. There are violations there even today. And cases are done. But different kind of violations, the requirements and the needs are different there. So, grievance redressal, one is the Office of Chief Commissioner. Now, remember that Office of the Chief Commissioner, if you go by the law, is not empowered to take public interest litigation. So when you file a case, always keep some individual's matter in the center, court. And generic issue, they do take up, but then they say, well, who is the affected party? They can sue you to also take up cases and monitor the work of the ministries, which they never do, because they themselves are part of the ministry. So we can imagine, if I'm an independent body, I can write to anyone. If I'm a part of the same ministry, under which I work as chief commissioner, then my colleagues in other ministries will get angry if I start writing because I'm equal to them. So there is a problem. We should have a full-time chief commissioner, which we don't have for many years, as we know now. We are talking, other Swaminathan was saying about state commissioner. What state commissioner? Yeah, chief commissioner is not there. Commissioner is not there in the center. This is how seriously the government takes the RPD. As you should understand, we need to lobby. Now, what happens to the office of the chief commissioner? Sorry, this noise I can't control. There's a construction going on at the back, so I cannot stop that. But I hope that you are able to hear me clearly. Yeah. So the chief commissioner, what does he do? He or she, after hearing, makes a recommendation. It's not an order. So if I'm a government body, I say, good, you send a recommendation, I keep it pending, and I will not implement it. Then everybody go to High Court, we'll see what we can do. So it is effective virtually. I mean, if I'm a decent person, I implement. But if I'm not decent, I say, no, I don't implement. Because there's a rule in the law, there's a provision, that if you don't want to implement the recommendation, perfectly okay, no problem. But give reasons within 3 months. So if I give reason that it is not possible to implement due to various administrative constraints, that's a good enough. And where do I give the reason? I give to chief commissioner and to the petitioner, fine. But what does the petitioner do with this? He or she has to go to High Court. So if I have to go to High Court anyway, why do I need to go to chief commissioner first and waste my time? But there's one use. If there's a favorable order, in the case of by the chief commissioner, and even when we go to High Court, at least we use that order to our advantage. That a specialized expert body, a statutory body under the law, has given the order. So we should now, High Court should implement. We have a similar case in AICB, where one of our advocacy committee member, Tarun Gupta, I don't know where he's joined. Tarun, are you there? Ashwarya, is Tarun Gupta there?
I don't think he's here.
No,
Achha, okay, I sent him the link. He's our advocacy committee member. He's working in a bank. He was denied promotion from scale 2 to scale 3. We went to chief commissioner. We won the order. But then the other side has gone to High Court. The bank has gone to the High Court. We are contesting the case there. But because we have the order of the chief commissioner in our favor, we have some advantage. So it's not without disadvantages, but it is a much weaker office than it was at one time. If the time is not there, I would share the very first case I argued, because of which were hundreds of visually impaired persons who are employed as bank officers because of that case, which I argued in 1999 against Punjab National Bank, when 2 visually impaired persons were denied promotion, even the right to appear in the entrance test for promotion from clerical to officer grade, even the right to appear. They were not allowed to appear in the entrance test. And they were denied promotion. So that was my first advocacy case, which I argued. The office had newly opened. It was the 3rd case ever in the office of the chief commissioner since its inception. In the case number 3/99, anybody may verify that. 3/99 in the office of chief commissioner. The 3rd case after the opening of the chief commissioner, there was a 2-hour argument, and we got a very strong argument. And I argued the case as I always do. In chief commissioner, we don't use lawyers. I personally argue all cases. In all humility, I say I have never lost a case in the office of the chief commissioner, ever. From 1919 today, 23 years, I do not remember losing ever a case in the office of the chief commissioner. So, but then to achieve that, you have to be very careful. Not every issue should be brought to the attention of chief commissioner. We start doing advocacy on what we want, not what ought to be, what is under law. You have to be careful as to what issue you raise. We get many representation and many we need to deny because we don't find substance. Not every issue needs to be taken. If you take up an issue, argue substantively. There was a 2-hour argument in that case, and there was deputy general manager and senior lawyers of the bank were present. I was the only person. It was my first case. And I was told by the then deputy chief commissioner not to come for the hearing. That person said, then it's a weak case, you will lose it, your entire reputation will be spoiled, you're just beginning your career. I said, doesn't matter. And I went and argued. And the point was, the bank may have its own policies, but no policy of any organization can be against the law of the land. And this was the law of the land. Therefore, the bank's policy is overridden by the law of the land. And on that point, we clinched the case. So it's important to be involved in matters. So it's an effective institution, chief commissioner, and there are state commissioners with similar powers, used to a possible extent but don't be deterred by the negatives. And there are, which is something which is not much used, special courts which are set up to address grievances under Section 84 of the Act. Muthu, I'm going to eat into your time, it seems. Section 84 provides for setting up special courts to certain grievances. And particularly this is one good thing of RPD Act. For the first time, there are punitive punishments, punitive provisions for any default of the rights of the Act. Section 88 to 93, the time doesn't permit to read all of them. But the fine sometimes is beginning from 10,000 to 50,000 to even 5 lakhs. The imprisonment may be also for 6 months, but the chief commissioner is not, or the state commissioners are not empowered to adjudicate under these sections. It is the special courts to be set up by every state. So Delhi has set up special courts. Session Court 2 is a special court for this purpose. But not many cases are going there, let me tell you also. But at least what you should ensure as an advocacy issue is whether your state has set up special courts for persons with disability under Section 84 of the Act. It's very important to know whether such special courts are there. Because these are not there, then do advocacy to ensure that these special courts are set up. This can be also a very important area of advocacy. And because to go to chief commissioner and to enforce 88 to 93 or 95 is not right, because technically they are not obliged to. Recently, the state commissioner Haryana has passed order and given fine, but that order can be challenged in High Court. It will be struck down because the power doesn't exist with state commissioners or chief commissioner to adjudicate, and never do something which is not allowed in the rules. That's very important. That's why we try to find a way of push where we don't have space. Try to go where we have little space, create more. Where we don't have, create little. But at the same time, the more correct we are in our approach, in our thinking, in our action, in our planning, in our presentation, in our advocacy strategy, that's very important to learn advocacy strategies. The better results we get to empower persons with disabilities. Here are some of my thoughts on this. If there are any questions, I think maybe what we could do is 1044. Okay, I'll also cover RTI Act today. So what is the RTI Act? It's a Right to Information Act. So the first thing you should know is what is information. Information is any record, any document, any file note which is available in a government office or in an organization which gets support from government for that particular project. So first thing, the biggest mistake people make while filing RTI, they ask questions. You cannot ask questions under RTI Act. You can't ask questions. Why was the policy not implemented? You can't ask questions like that in RTI Act. You can say provide documents relating to the non-implementation or the implementation of the policy. You have to phrase your question in the affirmative, not in the interrogative. That's very important. Then second thing you should note under RTI Act is that don't ask personal questions. What is the name of the officer handling disability? No, you can't. You can ask designation, you can't ask name. You can't ask people's salaries and so on and so forth, because the personal information cannot be given without third party. Then under Section 81J, information can be denied us in larger interest and their whole clauses. Read the Act. But the point is how we can use the RTI Act. I'm just rushing through it because there's no time and the next speaker is joined. So how can we use the RTI? Because that should be the first channel of advocacy before we go to a court of law. Because when we go to a court of law, we should have proper information, proper documentation, all facts. Now, how do we get these facts? These are not there in public domain. These may not be there on websites. And these should be authentic. We can't say we have heard so-and-so or we believe so-and-so. We know. Even the disability data, unless we can quote a censor, we can't say the 10% of persons are disabled. How do we know that? There has to be a data there, some source, some quoting, some authentic source. And RTI Right to Information Act provides us with the means to go through the most authentic sources and make your questions as specific If you make the question general, you would also get general answers. As I say, we know the skill. Being in the government myself, we know the skills how to get by RTIs. And Smita, being the advocate, also knows how to make us write the right answers. So it's both sides. It's a good battle that goes on. So important is that you ask very specific questions. Ask information in documents. Don't ask questions. Seek information and be specific. And as I told you earlier, if you don't get information in the first instance, then don't give up there. Go to the first channel of appeal. Go to the Central Information Commissioner or the State Information Commissioner and not be satisfied till you get your information. But RTI is very important. AICB has used RTI as a very effective means to do advocacy, not for judicial activism, but also for education. We have got a lot of work done under the Sarv Shiksha Abhiyan through the RTIs. So use this as a very important tool. We can talk more about this, and we can take questions on my earlier topic on reservation and employment and grievance in the valedictory session. Then we would have some time. Thank you.